Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar to learn more about special posting requirements for businesses with remote workers. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and we will try to answer as many questions as we can about the material presented via follow-up emails after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley's been practicing labor and employment law for more than 20 years, representing employers in a variety of matters, from discrimination and harassment litigation to defending FLSA class action lawsuits. Here at Poster Guard, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. As a special offer to our attendees today, Ashley will be available to set up a complimentary personal consultation about your specific posting compliance needs. If you're interested, please indicate that in the question box, and we will contact you to set it up. And here's our presenter, Ashley Kaplan.
Thank you, and welcome, everyone. Today, we're going to talk about labor law posting compliance and your specific obligations when it comes to remote workers. And when we talk about remote workers, we're including all of your off-site employees, whether they work from home, out in the field, on the road, or even at off-site remote locations like construction checkpoints or mall kiosks or even mobile service units. And dealing with mandatory posting laws for these kinds of workers can be really tricky. We get a lot of questions on this. The law says you have to communicate all of the same information about their rights as you do for your on-site employees. They're entitled to the same rights and notifications and information as any other employee. But you do have options in terms of how to communicate the required notices. You don't necessarily have to send out full-size laminated posters that go on the walls. There are other options. And our legal team here at Poster Guard has done all the research, and we're constantly monitoring the trends and evolving laws around this area, what the government allows and how to satisfy your mandatory posting obligations. So we can provide you with all the information and solutions you need to stay in compliance when it comes to your off-site workers. So today, we're going to go over the current employee posting requirements, what you're required to communicate when it comes to your remote workers, and the different options available for meeting those requirements, including different formats and delivery options. We're also going to cover some related trends and recent law changes that apply to all of your employees, including your on-site employees and your remote workers. Things like city and county posting requirements and all the changes that we're seeing on the local level. And finally, we're going to take a look at some pending poster changes, federal, state, and local, that we're watching right now as of today that will likely affect your posting obligations over the next few weeks or months in terms of mandatory posting updates. And again, that's for all of your employees. So first, let's start with a basic understanding of what postings are required. And it's important to keep in mind as we go through all of these that whatever information you're required to post on your walls also has to be communicated to your off-site workers. So just keep that in mind as a general rule. Whatever postings are required to be up on your walls also need to be communicated to your remote workers. So today's posting compliance environment is more complex than ever. As most of you probably already know, all businesses in the U.S. have to post both federal and state employee notices. And if you're in a city or a county with mandatory posting requirements, you have to post those too. So it's not just federal and state anymore that you have to worry about. There are also local posting requirements. Currently on the federal level, there are 6 mandatory postings, and they're listed here on this slide. First, there's the posting issued by the EEOC, the Equal Employment Opportunity Commission, and this one covers anti-discrimination provisions and protected characteristics under federal law. Next is the OSHA posting, and this one highlights important provisions of the Occupational Safety and Health Act. Next on the list is the FMLA. This is the Family and Medical Leave Act, mandatory posting. Then we have USERRA, which stands for the Uniform Services Employment and Reemployment Rights Act. And this notice covers reemployment after military leave, anti-discrimination provisions, and then other issues like health insurance affecting veterans and those serving in the military. Then there are two more on the list, and both of these actually had mandatory updates in 2016 at the end of the year. I just wanted to point that out. First, there's the FLSA, the Fair Labor Standards Act posting, and this one notifies employees about the federal minimum wage rate, overtime rules, and there's a lot of information on there about child labor laws, federal child labor laws as well. The mandatory update at the end of 2016, it was actually issued, I think, in July or August, incorporated a few major changes. The changes included information about misclassification of independent contractors, not the exempt, non-exempt classification issue, that's separate. But this poster update had information about misclassifying independent contractors. Also included information about mandatory breaks for nursing mothers, and also the increased penalties under the Civil Penalties Inflation Adjustment Act. And that's a law that actually increased the penalties for various violations under federal employment laws, including posting violations, which we're going to talk about in a minute when we go over the risks of noncompliance. But that was part of the reason why this poster had to be updated, because they were addressed on the poster. And then finally, there is the EPPA, which stands for the Employee Polygraph Protection Act. And this one lets employees know the rules around lie detector tests in employment. And this poster is mandatory, of course, even if you don't use lie detector tests. I get that question a lot. And the reason this poster was updated in 2016 was also to reflect changes in the penalty structure under the Civil Penalties Inflation Adjustment Act, just like the FLSA poster. And like I said, that law actually affected penalties under most federally enforced employment laws. But these two posters were the only ones that had mandatory updates because of it. You know, each agency operates independently, so sometimes there's not a lot of consistency across agencies or, reflected in the posters. Okay, so those are the federal posting requirements. And then on a state level, there are additional mandatory postings that are required for every business. Depending on what state you're in, this can add up to 15 additional posters. So that would be a total of up to 21 federal and state postings per location. And this area of compliance on a state level is definitely becoming more complex and difficult to manage over the years because more and more laws are being passed on a state level giving employees protection in employment. And whenever there's a new law, there's a potential poster update or in some cases a brand new poster, a brand new law that never existed before. Even as we see laws being rolled back or changed or tweaked in any way, not necessarily giving employees more protection, the result is usually a poster change or mandatory poster update. These state posters cover topics typically such as state minimum wage rates, fair employment, unemployment insurance, workers' compensation, state laws around smoking in the workplace, paid sick leave, child labor, and then some of the newer areas that we're starting to see like human trafficking, expanded family care rights, and even electronic cigarettes in the workplace. So like I said, on top of this, you may have additional posting obligations if you're in certain cities or counties with their own posting requirements. And this is an area where we've really seen a lot of growth. There's been so much growth in terms of the number of new city and county postings being issued and also the number of updates for these posters. And that's really taken off over the past couple of years. And, of course, that's what we're going to be focusing on today. Like I mentioned, you can have up to 9 additional postings just for city or county compliance. The city with the most, the one with 9 postings, is actually San Francisco, and I'll get into the specifics on that. But there are other cities and counties with multiple posters as well. It's not just San Francisco. So as you can see, there's a lot to keep up with to stay in compliance. And then on top of this, if you're in certain industries or if you have any government contracts, federal government contracts, or if you have a significant number of employees who are not proficient in English, then there are even more mandatory posting requirements that will apply to you. Federal contractors, for example, now have up to 15 additional postings, depending on what kind of contracts you have, and in some cases the amounts of the contracts. But it could be up to 15 additional postings on top of what we're talking about. Okay, so this is a list of the major cities and counties with their own posting requirements. And just a side note, this isn't a complete list. I've just included most of the bigger ones and ones that have had recent mandatory updates, over the past 6 months or so. But this is an area that's changing constantly, and it's really a lot to keep up with. More and more cities and counties are passing their own ordinances now requiring these employee postings. There are actually new ordinances coming out almost daily that our legal team is analyzing to determine if there are posting requirements. And so, this list just keeps growing. And these city and county postings, by the way, have to be displayed in addition to the federal and state ones, even if the information on the posters seem to conflict. We get a lot of questions about this. And this is, like I said, we're seeing a lot of growth in this area, similar to what I said with the state postings. It's really because local governments are expanding employee rights. So just to give you the framework for how it works, states, by law, have authority to pass laws that are more generous to employees than under federal law, and local governments have authority to pass laws that are even more generous than under state law. So typically, you'll see that states, if they have their own minimum wage rate, it's a higher minimum wage than under federal law. And then if a city has a minimum wage rate, it's even higher than under state law. And these posters, by the way, cover a lot more than minimum wage. That's just the easiest way to illustrate. So that's just an example. They cover things like paid sick leave, fair employment, a lot of the same topics as on a state level, just with more generous rights and protections. So as a business, as an employer, you have to follow the law that is the most generous to your employees. So with minimum wage, for example, you have to follow the highest minimum wage rate out of the federal, state, and local. Or if there are different periods for medical leave under federal, state, and local, you have to follow the law that gives employees the longest period of medical leave. But you're still required to post all of the posters. So you might have 3 different minimum wage rates up on the wall. And, of course, that goes for your remote workers, too. You still have to communicate all 3 levels of information. So remember, anything you're required to post on your walls also has to be communicated to your off-site workers. Another thing that a lot of people aren't so familiar with is that there is not a one-stop shop for free government posters. There's not a central place or a website or, an agency web page where you can get all the posters you need for federal, state, and local compliance. There's actually, across the nation, there are about 175 different agencies that are responsible for issuing the posters, and that's just on a federal and state level. And right now there are about 370 different mandatory posters on a combined federal and state level. And of course that doesn't take into account all the additional local postings, the city and county postings that I just talked about. Just talking about federal and state compliance right now. So in any given state, just managing posting compliance in one state, an employer would have to go to up to 9 different agencies to get their required posters for federal and state compliance. And then on top of that, there are also about 22,000 cities and counties, and each has their own governing agencies and ordinances to monitor. Luckily, at this point, not all cities and counties have their own posting requirements, but a lot of them do, and like I said, we're seeing this number grow every day. And none of these agencies, whether it's federal, state, or local, these agencies do not have work share agreements where they would provide all the posters that a sister agency would require. They act independently. In some cases, I've seen some states that do a pretty good job where there's some crossover, where some agencies will try to help out and you could get some poster from another agency on their website. But the posters are governed and enforced independently, so it's not a complete list. And there just simply is not a one-stop shop where you can get everything you need for federal and state compliance, and certainly not on the local level, the city and county postings. The local agencies really operate on their own, apart from the state and federal agencies. So adding to this complexity is the fact that posting changes are also on the rise. Our legal team here at Poster Guard monitors and tracks all the poster changes on a daily basis, and on average, we see about 150 state law posting changes a year. And every time there's a posting change, we review the underlying laws to determine if it's mandatory or non-mandatory. And at least half of the state law changes do require a mandatory update or an immediate replacement of the posters. And then on a local level, sometimes we get 2 or 3 mandatory changes in a week. It just depends. We see even more changes. We see most of the changes near the end of the year when a lot of states and cities raise their minimum wages, but poster changes happen all year long. Sometimes they're expected, and they're, the laws have made it through the legislative process, and we can see that a poster is about to be issued. Other times you can't really anticipate it, and an agency will just issue a poster update, and it happens throughout the year. And by the way, at the end of the presentation, we're going to take a look at some of the pending changes that we're watching right now, posters that are due to have mandatory changes based on laws that have recently been enacted, as of today on a federal, state, and local level. We'll get to that at the end of the presentation. So finally, another problem that adds to the complexity is that the government agencies don't notify businesses when these posting changes occur. So this can be really difficult because the posting requirements and the notice of change can be buried on different agency website pages. And a lot of times the old poster images remain up on active website links with no indication that they're no longer compliant. They don't always redirect you to the most current version. And sometimes the posting guidelines, who the posting applies to, whether there are foreign language requirements, whether they're mandatory, whether they have size, font, or color requirements, all of this can be buried sometimes on different agency web pages. They can even be in statutes and regulations. On a city level, we're finding that they're even buried sometimes in case law, in court cases. So it can be difficult to find the changes, difficult to interpret whether they're mandatory, whether they have compliance deadlines, and whether even determining if a poster is mandatory in the first place can even be challenging. Sometimes a poster update will come out and they're just cosmetic changes. Sometimes only one word will change, but the agency indicates that it's mandatory and has to be updated. Other times the poster will completely change, the content changes, the look and feel changes, but if you research it a little further, you can confirm that the old poster is just fine and you don't need to update the poster. So, and that's one of the things that we handle for our Poster Guard members. The legal team researches and analyzes all of this for each poster change, and we communicate that to you. I included this slide because there's a lot of confusion about the risks associated with labor law posting compliance, and there have been some recent changes to the penalty structure that are pretty important, so I wanted to cover that. So I get a lot of questions on this, and I hear 2 things a lot. The first is that government posting fines are so small that it doesn't really matter if we get caught. And the second thing I hear a lot is, well, there are no poster police out there, so how would I ever get caught anyway? So I'm going to address both of these misconceptions really briefly. First, when it comes to the amount of the fines, the amounts are actually pretty significant, and they can certainly add up if you have the same types of violations at multiple locations. The penalty structures are per location or per violation, so they can add up. In the statutes for the regular federal postings, just talking about federal postings, government is now authorized to fine up to $33,000 per location for posting violations. It's actually $33,486, and that's based on the most recent increases that just went into effect in January 2017. And government fines typically are imposed either for missing posters or outdated or old posters. And as I mentioned when I was talking about the federal poster requirements on the very first slide, this penalty amount first increased as part of the Civil Penalties Inflation Adjustment Act. That went into effect in 2016 and caused those 2 mandatory poster updates. Before that, the federal fines for posting violations were only around $17,000 combined. So that's a pretty significant increase. It's almost doubled. And the Civil Penalties Inflation Adjustment Act actually calls for increases going forward each year to keep in line with the inflation rate. So they were increased again in January 2017, and they're expected to gradually increase going forward each year. So that's for the federal postings. On a state and local level, the government posting fines are typically between $100 and $1,000 per violation. Each posting has its own fines attached to it, so they're really all over the place. There is a California poster, I think, that carries a heavier fine. I think it's $7,000. But in general, this range here on the slide is pretty accurate. Like I said, every agency and every posting law is different, but in my experience, I typically see state and local fines come in the range of about $500 or up to $750 per violation. Okay, the second misconception I mentioned is that there are no poster police out there, so there's really no need to worry about government posting fines. Well, the reality is the federal government rarely sends out representatives to businesses just to enforce posting laws. That's true. We actually have seen this on a state and city level where there have been poster sweeps by enforcing agencies or even the state attorney general. But on a federal level, government posting fines typically are assessed because the agency's on your premises for another reason. It could be an immigration-related issue. It could be an OSHA inspection, an EEOC on-site investigation, or even more commonly, just a Department of Labor audit that was triggered by some kind of employee complaint, a current or former employee. And the complaint or the investigation is usually completely unrelated to the posters, but of course the agencies always check posting compliance as part of any on-site visit. It's one of the first things in their field operation handbooks to look for. But the real danger when it comes to posting violations is actually related to employee lawsuits and employee disputes. It's not just about government posting fines. And there are a few different ways that posting compliance comes into play with employee lawsuits. The first, and I think the most significant, is when it comes to the statute of limitations. In my experience defending businesses in employment litigation, I like to refer to the statute of limitations as an employer's best friend because this is the defense that allows you to have a claim stricken, completely dismissed just because it was filed too late, even if there is an underlying violation. These can be erased and dismissed. The statute of limitations, for example, in a federal discrimination claim is 300 days. In a Fair Labor Standards Act case for, overtime or misclassification or wages owed is 2 years. So typically, if you get a claim from a former employee or a current employee for a violation that occurred outside of that window, outside of that time period, you can move to have it dismissed and avoid all the legal fees and potential liability for the claims in the lawsuit. You can also use it also cuts off damages for violations that occurred before that statutory time period kicked in. So it's really helpful. It's really important as a defense in almost every case, especially if you have multiple plaintiffs or a repeated violation that goes back into time. The problem is if you have a posting violation, either you didn't display the current poster or you're missing a poster, courts have begun to publish more and more decisions saying that if an employee didn't have proper notice of their rights, that the statute of limitations is extended or tolled and you cannot use it as a defense. So we've seen cases where normally an old claim could have been dismissed, thrown out, where the court allowed the plaintiff to pursue the claim and it ended up in a six-figure judgment just because the posters were not up on the wall. Another way that posting compliance comes into play as evidence of bad faith. And that could be in any related employment lawsuit, any of the laws reflected in these posters, whether it's Fair Labor Standards Act or discrimination or an ADA case. Each law is a little different in terms of the legal standards, but a finding of bad faith or lack of good faith, depending on the legal standard, can directly affect your damages, either by inflating a damage award against you, or it could stand in the way of a good faith defense that you might have tried to assert that would otherwise have reduced or eliminated your damages. It stands in your way. And we are seeing more and more cases where posting compliance is one of the factors that courts look at when they're assessing these kinds of damages relating to good faith or bad faith. By the way, we have a white paper with all the case law on this. There are lots of examples where this is played out, these theories that I'm talking about. So if you'd like a copy, just indicate that using the chat feature, and we'll be sure to email it to you after the presentation. And then finally, there's a point on here, under the FMLA, you can actually be faced with a civil lawsuit if the failure to post ended up interfering with someone's FMLA rights, like if they didn't have the information they needed to know, how long they had to be out, that they needed medical certs, how to return to work. So if it caused harm, there could be grounds for a civil lawsuit. So these are pretty severe consequences that you need to be aware of. It goes beyond government posting fines, and obviously good reasons not to take posting compliance lightly. Okay, so before we jump into the specifics for your remote workers, I realize that some of you attending today's webinar may not be familiar with PosterGuard and how it works. So just to give you some context, I want to take just a minute to go over some highlights of the program, and specifically how it will help you stay in compliance with all of these posting requirements that we're talking about today. So here's how PosterGuard works. Upon your enrollment, and first we're talking about your facilities, your physical posting requirements. Upon your enrollment, we start you out by sending all of the mandatory federal, state, and local labor law postings to each of your locations. And this local piece is really important. We've actually expanded our service to automatically include city and county postings for all regions of the United States. So our legal team has grown, and our attorneys and researchers are now continually monitoring all local ordinances and agency activity for all the jurisdictions. It's more than 20,000 cities and counties to make sure that our customers are in complete compliance. Once you get your initial postings, we take care of everything from there. Our in-house legal team monitors the posters daily for changes, and whenever there's a mandatory update or a new posting requirement, we automatically notify you and immediately send out the new posters at no additional charge to the affected locations. And that works throughout the year, no matter how many posting changes there are. So even if your location doesn't have a local posting requirement yet, if you're in a city or county that doesn't have a posting requirement yet, if a new ordinance pops up while you're a PosterGuard member, you're covered. You would get that poster automatically as soon as it's released by the agency. Just a couple more details about the PosterGuard service. All of the posters are monitored and reviewed by our in-house legal team, and we adhere strictly to all size, font, and color requirements. And this is true for all our posters, fed, state, and local, and all the different formats. And it's something we take really seriously on the compliance team. Our legal team analyzes each posting requirement to check for size, font, color requirements and foreign language requirements, and we adhere to them strictly. When it comes to the physical posters for your walls, we do shrink the posters as much as we can. We understand, wall space is important, but, we try to save on wall space, but we will not shrink to the point where it compromises compliance. A lot of these posters have minimum size font requirements. Like I said, we will always comply with that. Also, we automatically include all the posters in whatever mandatory languages are required. And this is done at no extra charge to make sure you're in compliance. So whenever a poster is required in a foreign language for all employers, even if all your employees are English speaking, there are laws that require certain posters to be posted in Spanish or other foreign languages. If it's required for all employers, no matter what, PosterGuard automatically includes the foreign language versions with your English service. And like I said, that's true for federal, state, or local. So right now, there are 23 states, it's actually 22 states plus Washington, D.C., that do require certain postings, not all the postings in those states, but in these 23 states, certain postings are required to be posted in Spanish, even if you have no Spanish-speaking employees. When it comes to the city and county posters, we see it's even more common. A lot of these city and county posters have to be posted in multiple languages, sometimes in 4 or 5 different languages, and that's for all employers. So, like I said, if the law requires every employer to post something in a foreign language, we include the translated versions automatically at no additional charge. And this is really because we want to make sure you're in compliance. We believe if it's mandatory, you shouldn't have to research the law and ask for it, or even know whether to ask for it, or be forced to pay extra to be covered. It's all included. And finally, Poster Guard provides a 100% guarantee against government posting fines. And this means that if you're a Poster Guard customer and you receive a government posting fine when you've properly displayed the most recent version of our posters, or you've properly used our remote worker solutions that I'm going to talk about in a minute, we take full responsibility for the fine. And by the way, something else worth mentioning when it comes to litigation, to help further protect you against damages and lawsuits and disputes, we also provide complete record keeping. So we maintain up to 5 years of records, and we provide our customers with all the evidence and data that you need to respond to any requests in litigation or in a government investigation, to help to prove that you were in compliance when it comes to all these posting laws and everything applicable to your business. So now we're going to talk about your specific obligations and how to comply when it comes to your remote workers. So first, let's go over the laws around electronic posting. And this is something we watch very closely. Our legal team has been in contact with the government agencies. Our product innovation teams have been working closely on next generation solutions. As soon as digital posting becomes legal, we're ahead of the curve on that. But and we're constantly monitoring all the case law and the bulletins and the opinion letters that are coming out and the posting regulations. But unfortunately, the government agencies, when it comes to posting compliance, haven't really caught up with the modern technology of today's workforce. So this means for your physical locations where your employees report to work, the general rule is still that electronic delivery is not a substitute for the full-size physical posters on the walls. The posters still have to be posted in conspicuous locations, accessible to all employees, in physical format, posted on your walls. Now, there are a couple of exceptions, and really we see this as new regulations come out under federal law. So the government is addressing it. We've seen it with some of the more recent federal contractor postings. We've also seen this with the most recent FMLA regulations, and even back when the USERRA notice came out, where the government said it was okay to communicate these posters, just these that we're talking about, electronically, but only if you communicate all your other employment policies electronically, and you have to make sure that your employees have internet access and are receiving them electronically. So that can be kind of difficult to stay on top of for a lot of businesses, and it really depends, I think, primarily on, if you provide your employees with electronic access. You also have to know that they either have a computer or a mobile device or some way of accessing the posters if you're going to rely on these and communicate electronically and post electronically. It's also difficult because since it's only a couple of the posters that you can do this with, and you still are obligated to post the others on your walls, most businesses choose to just go ahead and treat them all the same. It's just easier to manage that way. So going ahead and continuing to post all of the federal posters on the wall and not communicate them separately electronically. So that's the general rule. There are some exceptions, though, when it comes to your off-site workers. So now we're going to talk about some special rules when it comes to telecommuters, people who work from home or off-site, field workers, and also non-traditional work sites that don't have walls. There are some exceptions. So first, let's talk about remote workers and telecommuters. Over the years, the Poster Guard legal team, we've gotten questions from customers, going back 10, 15 years ago, asking, what do? We have employees who work from home, and they've tried to order full-size wall posters that they wanted to send to their employees' home addresses to make sure they're in compliance. We've all kind of laughed in, trying to imagine, if you're working from home, having to post these posters on your refrigerator or on the back of your bathroom door, how would that work? And obviously, that really wouldn't work in most cases, and that is not required. But it is kind of confusing because by law, you are required to provide the mandatory labor law notices to all of your employees, but the law doesn't tell us exactly how that's supposed to be done. They do tell you that you're required to communicate the information, but they don't tell you that you have to use a certain solution or format, or whether it even has to be paper or electronic. The options are open. But there are some recent opinion letters and court cases where employers have sent notices electronically, and the courts have said that is a good alternative, that makes sense, you got the notices to them, and that's what counts, so that is a compliant solution for your off-site workers, getting it to them electronically. As long as the information is communicated and you have some way to establish that and a system in place, that's a compliant solution. So to help our customers comply, we've developed Poster Guard e-service for remote workers, and this is really, like I said, it's not a substitute for wall postings if you have a facility where people report to work, but for your off-site employees who have internet access and either have computers or mobile devices where they access email and communicate with the office via email or internet, this is a fully compliant solution for those employees. And one question I get a lot before we move on is, what if our remote workers, or we have telecommuters who visit our facility from time to time, and they have access to the posters on the wall when they are at our facility? Are they still considered remote workers for purposes of posting compliance? Or is it enough that they have access to the physical wall posters when they visit? How often do they have to have access to the wall posters? And this is a great question. The law isn't 100% definitive on how frequent an employee must access the physical wall posters to be covered, especially since all the posters are enforced by different agencies and under different laws, federal, state, and local. But there are a few good opinion letters out there from the government and FAQs that the federal agencies have published that provide some guidance for this. So, for example, in responding to a question on this, the U.S. Department of Labor has stated, and this is a quote, if an employee reports to your physical location at least 3 to 4 times a month, then physical posting is all that is needed. If your remote employee does not visit the office this frequently, then electronic posting should also be done. So that's the standard that most employers go by, based on that federal guidance that we have. If an employee reports to a physical location with the posters on the wall at least 3 to 4 times a month, you're covered. If not, you need to consider an electronic solution or some other method of getting the posting content to those employees. Okay, so this is the way the Poster Guard e-service for remote workers works. You provide the email addresses and the zip codes to us of your remote workers, and then we pretty much take it from there to communicate everything to the employees and to keep you in compliance. So once we have the email address, we send a welcome email to the offsite employee, and the email has simple instructions and a link requiring the employee to download and view the poster images. This gives the employee access to all the posting images they need based on the zip code. It covers federal, state, and any city or county posting requirements that apply. Also, if any foreign languages are required for all employees, those would also be visible when the employee clicks. You can also add services, by the way. Like if you're a government contractor and you need the employee to receive the federal contractor postings, you could also indicate that, and that the link would also take the employee to those mandatory postings as well. All of the posting images are hosted by us on our secured network, and we make sure that whenever your employees click on that link to view the poster images, those images are correct and up to date. It's actually managed by our legal team. So the legal team makes sure the images are updated immediately when there's a mandatory change. The welcome email that is sent to the remote worker with the link to the poster images, it goes out immediately when you enroll that employee in the Poster Guard e-service. And then whenever there's a mandatory change or a new posting requirement, we automatically send another email to that employee with the same instructions, letting the employee know, there's been a change, you're required to click here and view the updated images. And when the employee clicks to view the images, an employee acknowledgement is automatically generated and saved for your record keeping. And you can retrieve this information anytime you need to. It's all stored on our secured web portal at posterguard.com, where you have all your account information and everything. It's saved right there with your physical deliveries and shipments. Just like you could see UPS deliveries, for example, you can also see all the electronic acknowledgements. So, these acknowledgements, I think, are really great because, this tool generally just provides full tracking. You've got all the dates and times when your employees acknowledge the posters. And this is really useful. I can tell you from experience as a litigator, whenever there's a dispute about an employee notification or a policy, and it's really common with employee handbook policies, where employees will say, well, I didn't know about that rule, or I didn't get that update, no one told me there was a change, I didn't get that memo. And in this case, with the e-service, you have proof and tracking for backup. You have everything you need to show that the employee, in fact, did view and acknowledge all the postings and all the mandatory updates, and that you've complied, on your end with all the posting requirements. So once the employee receives that initial email with the link to the images, they can always go back in and view the poster images on their own time. It's not just a one-time thing, and this is for compliance reasons as well. They just need to log back in with their email address. So this screen shows what it looks like to the employee, to the remote worker. And by the way, this only gives them access to the posting images for their region and what you've selected for them. It doesn't give them access to any of your account information on posterguard.com. It's completely separate. So they're just accessing the employee-facing posting images. This next slide shows what it would look like if an employee were to log in and maybe they have some posters they haven't yet viewed. So, maybe if, for example, if you've set them up with additional posters like federal contractor postings or additional posters that are translated in foreign languages. If they didn't view everything immediately when they got that email, and they go back in, this shows if they have posters that they still need to view. And then, of course, once they click on them, the acknowledgement is automatically generated. It changes colors, and it's all saved to your account. In terms of the acknowledgements, it's also this system makes it really easy for the administrator to keep track of everything and to keep track of each employee acknowledgement if that's something that you're managing. So first of all, there's an automatic email that goes to the administrator every time an employee acknowledges a mandatory poster or update. And this, of course, is something you can elect to turn off, especially if you have a lot of remote employees and you don't want to get these notices. We have some customers with thousands of remote workers, and understandably, they don't want to get an alert every time someone acknowledges a new posting. But others do use this as a way to track what's going on as it's happening. So it just depends on your own system. Also, the administrator can view the status for each remote worker at a glance anytime, on your own time on posterguard.com. And the screen is actually really easy to navigate. You can filter and sort by delivery status. So you can determine, who's received the emails, who has viewed the posters, and who has not. And then all of this can be exported into Excel or any other reporting format to help with follow-up. So it's really fast and easy, whether you're managing just a few remote workers or if you have somewhere in the thousands. Okay, so next we're going to talk about remote work sites, where your employees report to a workstation or maybe a checkpoint, but it's a non-traditional work site that doesn't have wall space for all the required posters. So this is a trend that's really popped up more and more in recent years, and really there are a lot of workstations and work sites out there today that don't have walls or any way to hang up these required posters, especially when you take into account, we talked about California and San Francisco. If you were to add up federal, state, and city posters, it's somewhere around 28 posters. So some good examples of these non-traditional work sites without walls are mall kiosks, the little kiosks that you see in the middle of the mall. They don't necessarily provide internet access or any kind of mobile device for the employees, but they also don't have walls. And in that case, you're not excused from posting compliance. You still have to find another way. Some other examples of these non-traditional work sites are like construction checkpoints, valet stations, and mobile service units, which are really growing in popularity, especially in healthcare, where we're seeing a lot of new mobile service units for things like MRI, kidney dialysis, blood donation trailers, and then of course we're seeing more and more of these food trucks, and food and beverage services on wheels also. We've also seen it where, a lot of businesses have employees performing services on another company's property, like, you're contracting with another company. We've seen this, for example, with janitorial services, where, for example, there's, just sort of a checkpoint where employees go to get their supplies. Maybe it's just a closet or a storage area or even, a mobile cart, but there are no walls. So in these cases, you're still required to comply with all the posting requirements. So we've developed a separate solution to help with these scenarios. So to help you comply, we've developed a binder solution, and it includes all the mandatory federal, state, and local posters that you need for complete compliance. All of the posters are printed on like a hard, durable paper stock, and they fit into a compact binder with rings. It's 11 by 17. The reason that it's that size, 11 by 17, is to ensure that it complies with all of the size and font requirements under federal, state, and local law. And it works just like the regular Postal Guard service. Your new locations are sent the complete binder to get started, and then we monitor all the postings. Whenever there's a mandatory change or a new poster that's required, we automatically send the pages that need to be updated. And since it's part of a binder system, it's really easy to remove the old and insert the new, and that way those locations are always in compliance. I just want to emphasize again that this is not a substitute for the regular full-size wall postings if you have a facility with walls. This is only designed, and it was specifically designed for those non-traditional workspaces we're talking about, where you don't have walls to hang all the required postings. Okay, as promised, we're going to wrap up the presentation with an overview of some of the mandatory poster changes we're monitoring right now based on laws that have already passed, that have already been enacted and have been passed as of today. So this slide highlights pending changes based on federal, state, and local laws that have already been enacted. And these laws make the corresponding posters outdated. The information on the posters don't match up with what the laws say. So they will require mandatory poster updates with the new information. So typically, a law is passed and the government updates the poster before the compliance deadline or the effective date of the law. But that is not always the case. Sometimes a law will go into effect and the government takes weeks or months to catch up and get the new information onto the posters. So, just because if a law takes effect on January 1st, that doesn't necessarily mean the government agency is going to issue the poster before January 1st. It could happen, December 30th. It could happen January 15th, and in some cases we've seen it happen months later, even over a year later. But as soon as the posters are released, that puts everything in action, and we send the automatic replacements to get you into immediate compliance. So on this slide, this is just a list of laws that have actually been passed with actual effective dates. There's a host of other bills that are pending in various stages of legislation that could also affect these posters. So on a federal level, for example, the posters may be affected by pending bills that are out right now on issues like immigration reform, FMLA expansions, a lot of movement around the FLSA and debate around that. And then, as we've discussed, there are hundreds of bills that are pending on a state and local level as well. But this slide, like I said, it just captures posters that are due to have mandatory updates based on laws that have already been enacted as of today. Okay, well, that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of legal requirements and details, but there's really a lot to share when it comes to these laws and the complexity and your obligations, especially when it comes to posting compliance for remote workers. It's an area with a lot of confusion around it. So hopefully we've cleared some of that up today. If you have any questions or would like additional information about Poster Guard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfray, at hrdirect.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.